Good morning. It looks like we are live. Today is June 21st. It's 10 a.m. Central Time, where I am here in Minneapolis, Minnesota. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. And I do this educational live YouTube show to answer questions that people have about running a business or the law. All right, let's jump into the first question. Can the videos of content creators be published on social media platforms? I'm sorry, let me rephrase that. So, can videos published online, like on social media or YouTube, be monetized if they use images or videos owned by others? So, let's imagine that you are creating a YouTube video or a TikTok or an Instagram, and you would like to use an image from somebody else, or maybe you want to use a video from somebody else. Are you allowed to do that? The initial level of legal analysis says it is copyright infringement whenever you use something created by somebody else. But there's an exception called fair use. So that's a real high level overview. Let's get into the details. When somebody creates a video, an image, a song, etc., they automatically own the copyright in their creation. I'm going to call that their work. Whatever work they create, they own the copyright to that. But it's called a common law copyright because it's not registered yet. When somebody then goes and registers it with the US Copyright Office, now they have a registered copyright instead of a common law copyright. But whether it's a common law copyright or registered copyright, it doesn't change the fact that whoever creates a creative work owns that work. So that image, song, photo, video, whatever. So they own it. Now, whoever they give permission to use the work to, that's called a license. So if somebody has permission to use a photo, they have a license to use that photo. What we're talking about today is no permission has been granted. No license is available. So clearly, the use of somebody else's copyrighted work is copyright infringement. Now that we know it's copyright infringement, we say, do any of the exceptions apply, or the defenses is actually what they're called. And one defense is fair use. And some of the ways that fair use can be analyzed are as follows. First, are you transforming the work in a significant way so that it, and not essentially undermining the financial rights of the copyright owner? So let's talk about that for a second. Let's say, for example, that you do a YouTube video on one of your favorite books, and you hold up that book on the video and show the image on the front of the book, the cover of it. You are using an image and essentially making a video copy of it. Or you might go into Google image search and pull the cover of the book and put it up in the corner of your video before you post it on YouTube. You've clearly taken somebody else's photo and put it on your video. Now, you've actually infringed probably two copyrights there, because the book cover is one copyrighted work. And then the photographer who took a photo of the cover has a copyright in the photo, and now you are using it. So you're infringing two rights. Is it copyright infringement? Yeah, it is, because you copied something without permission. But does fair use apply? And the idea here is you are not undermining the financial rights of those copyright owners. Let's focus on the book author right now, because you're actually talking about the book and you're saying, hey, here's a great book. I love this book. You should go buy this book. Maybe you even give an Amazon link to buy the book. You didn't, that's very different from making a copy of the book and starting to sell copies. There, the people consuming your copies are not going to pay any money to the copyright owner. So there is a significant transformation in the copy of the book to the video, and you are not undermining the rights of that copyright owner. You also are only using a very small part of the book. It's not like you're reading the whole audiobook. If you did that, you probably are hurting the financial rights of the book owner. So by doing a video talking about this book, that is a very clear case of fair use. But let's say in that scenario is now a little bit different. Instead of talking about how much you love the book, you say how awful the book is and how you recommend people do not buy the book. Now I think there's a better argument that you are affecting the financial rights or the financial benefit the book author is hoping to receive from the book. But there's another exception under fair use that applies, and that is the right to criticize, review, scrutinize, and talk about a particular creative work, something that's copyrighted. I just watched a video by some other YouTubers. These were lawyers who were commenting on the Johnny Depp trial. And so they were taking copyrighted film footage from the trial, which was produced by one of the YouTube channels that cover trials and other criminal news events. And the YouTubers were rebroadcasting that video feed while commenting on that. And they were explaining that they believe it is a fair use case because they are not, or they are significantly transforming the work. They're providing commentary and additional value substantially more than they're not just copying the feed and reproducing the feed. But as you can see, there's no real bright line test like, oh, this is fair use and this isn't. It's gray. And it's intentionally gray because as experts have looked at changing this law and making it more clear, the concern was that might stifle free speech. And so there's a great desire in the United States to preserve free speech. And so in an effort to prevent banning certain sorts of speech, experts have erred on the side of having a spectrum or a gray line which allows for speech and allows judges later to decide, did somebody go too far in infringement? So that's a long way of explaining that content creators are infringing somebody else's copyright if they use any creative work without permission, but fair use then comes into play. And I might need to do a longer video on fair use, but this at least gives you a little preview. There's a second part of this question, which is monetization. Let me explain or I'll rephrase the question here. How does YouTube monetization relate to copyright infringement? It's not the same. Copyright infringement is a legal analysis. Monetization is YouTube's policy and contract with creators and with copyright owners. And basically, YouTube has said, we want to set up a system where if people want to infringe somebody else's trademark or their copyright, they should not be compensated for that. The compensation should go to the copyright owner. So let's say, for example, that I put out on YouTube a video of a musical artist, and I also add some commentary to that. Under copyright law, that may be covered by fair use. I might essentially have the fair use defense and would win in a copyright infringement case. But under YouTube's monetization policy, YouTube has said we're going to give once there is a claim made to that music, the money from that video will go to the music owner, not the person who posted the video with some commentary. Is it a perfect system? No. Perhaps a perfect system would be one where both parties are compensated for the amount of value they contributed to the video posted on YouTube. In other words, the music artist would get compensated and the YouTube creator would get some portion. But you have the option of doing that. In other words, you can go get a license to use the music, and then actually you will get all of the proceeds or monetization from that video. So you have every right to go get a license as a creator from the owner of whatever creative work you want to use. And then you get all the money. So basically, YouTube's policy has said, if you're not going to go the correct route and get permission or a license to use somebody else's creative work, that's fine, but you run the risk of being demonetized. In other words, you won't get the money from that video. The owner of the copyrighted work you used would get the money instead. If you have other questions on that, feel free to add them in the comments section below, and I'm happy to go into greater detail. If not today, at another time. Is it bad to own companies with similar names? We had a YouTube commenter who, Nisani, who asked, since I'm doing 3 businesses, would it be bad if most of them have similar names? You might see this a lot. Businesses might have McDonald's Corporate or McDonald's Holding Company or Ronald McDonald House or McDonald Holdings 7 LLC, McDonald Holdings 8 LLC, or McDonald's Minneapolis LLC. In other words, the McDonald's brand is essentially being utilized in a lot of different company names. Let's first talk about, can you do that? Sure. It's legal. There's nothing wrong with that. Can you run into problems with that? Yes, you can. And here's the scenario. It can be confusing for people working in these various companies to remember what is the name of their company and use the proper company name in every interaction. I'll give you a big example here. There's the Mall of America in Bloomington, Minnesota. I believe it's the largest indoor mall in the United States, or at least it was at one time. There was a big case called 555 v. Simon, and it was basically large companies suing each other over ownership and a partnership in ownership and control of the Mall of America. And in that case, there was a letter written by one company regarding the dispute, and it was written on letterhead of another company. So, in other words, one of the employees of the company used the wrong letterhead because they got confused. There are so many different companies. And the court said in one of its orders, the party had made no distinction between the companies, so the court will not either. It's a paraphrase, but essentially, because the owner of the company wasn't able to keep track of or was not distinguishing between the different companies, the court would not either. In other words, the court would pierce the corporate veil between all of these companies and treat them all as the same, treat them all as alter egos of each other. As a result, instead of a company having limited liability, other companies in the same family of companies had joint and several liability. And this was an expensive error because the court reached in and ordered that proceeds be disgorged, millions of dollars be disgorged and taken for one of the other companies. If you're wondering what disgorged means, I have another YouTube video on that. We'll put a link to that down below in the description. So what's the takeaway here? It's fine if you have companies with similar names, but it's very important that you treat them as separate companies consistently. They all need to have their own bank account, their own financial records. When employees work for the different companies, they need to log their time for each company, and each company has to make payroll to those employees. So, for example, if you're working for 4 of your companies, you need to make sure that you're being paid by all 4 of those companies. You can't just have your payroll coming from one company and then doing work for 4 of them, because that is not distinguishing between the 4 different companies, and you run the risk that a court won't distinguish between them later. Because to the extent you are treating them as alter egos of each other or commingling their funds or their resources, the court then can say, I'm not going to treat these as separate companies either. And now you lose all the limited liability. So is it bad to own companies with similar names? No, if you keep them separate from each other in all other aspects. But the more similar the names are, the more parties and employees and contractors can be confused about which entity they're working for or with. What do you do if you are falsely accused? This question came up because there is a tragic story out of Australia. In that story, Kathleen Folbig is a mother of 4 children who died. And when she was tried in that case, the jury looked at some information and concluded that she must have killed her children. Here's the information they looked at. First, the probability that 4 children in the same family would die from natural causes, the experts said that is statistically virtually impossible. I mean, it's hard enough to get hit by lightning once, but to get hit by lightning 4 times, that's kind of what the argument was here, that sure, maybe 1 child death was an accident, but not 4 accidents in the same family. That's just statistically unlikely. The second piece of information the jury relied on was notes from the mother's diary. And it included passages that talked about her just feeling so isolated and sadness and great depression and grief. And the jury concluded that that is the sign of a psychologically tormented person, and signs that she has enormous guilt over killing her 4 children. So this mom has served 20 years in prison. And recently, new scientific evidence came out that there was a genetic explanation for the children's deaths. So the prosecutor in that case, the lawyer representing the government, came out and advocated for this mom's release. And I think what's so tragic about this, and this is obvious, is it's awful to lose one child. How much more awful to lose 4 children? How much more awful than to then be accused of it yourself, that you did this to your children? And to add insult to injury, to then spend 20 years in prison? I mean, this mom has lived a horrendous sequence of experiences. And unfortunately today, as we are finding new technologies for DNA evidence, we are realizing that a lot of people are wrongly imprisoned through our legal system. So rather than getting into the politics of that and all the statistics and all the different kind of rabbit trails we could go off onto, the question today is, what do you do if you are falsely accused? The short answer is really simple. Contact an attorney with experience in the subject matter that you have been accused, or that you are facing crimes in. Now, you might think, well, that's obvious. Why are you even telling us that? Because a lot of times when people are falsely accused, they don't pursue legal help for a number of reasons. You might think, you know what, I didn't do it. Justice will prevail. The truth will eventually be known. Well, as we know in this story with the mom, yeah, the truth was eventually known, but it was after serving 2 decades in prison. So truth may be known eventually, but that may not be soon enough. Another reason people often hesitate to reach out to attorneys is because of the cost. But I can tell you that an ounce of prevention is worth a pound of cure, to borrow a phrase that I was taught as a child. In other words, getting in there early to avoid a bigger problem is far less expensive than waiting to defend it later. Next, an attorney can often help point you in the right direction for other resources that can be helpful, other experts. For example, maybe it's a therapist of some type, or a psychologist or a psychiatrist. Maybe it is a support group for others who have gone through something like this. Maybe it's educational resources like a book, or a site online. If you are falsely accused, I recommend as soon as possible reach out to an attorney in that space. If nothing else, so you have somebody lined up you can contact if very quickly things go bad. Here's the next question. Can you hide from lawsuits by using LLCs to own property? This question arose from Bruce Corter, who added a comment on YouTube, and I'll read that comment here. And this is a bit of a paraphrase, but it says, what is your opinion on some lawyers justifying the use of LLCs to hide ownership of real estate properties under the theory that what can't be seen can't be sued. I believe this is a flawed theory, and here's why. If an LLC owns real estate, that LLC can be seen and it can be sued. Why? Because it's registered with the state. So when you commence a lawsuit, you can sue the LLC and the address of the LLC. Once that lawsuit is started, you send discovery requests. Discovery requests can ask questions like, who is the owner of this LLC? Who's the president of this LLC? Provide a copy of all of the bylaws, operating agreements, meeting minutes of the governors or owners of the LLC, and even request other information relevant to the lawsuit. So, yes, there's a little bit of a slowing down of somebody finding out who owns an LLC if you have a real estate owned by an LLC, but it doesn't stop somebody who's trying to commence a lawsuit. If I want to commence a lawsuit against an LLC and the manager or owner of that LLC, I'll just sue the LLC and then I'll send discovery requests, and they have 30 days to provide either answers to all the discovery requests or objections to why legally they're not required to provide answers. So I don't believe you can hide the owner of a real estate or the manager of real estate simply by putting it into an LLC. You may be able to provide or hide that from public knowledge, but once a lawsuit starts, discovery can get at it. The same is true of a trust. I have celebrity clients who will own real estate inside of a trust. A trust does not have to be registered with the state. And that means that they can make up the name of the trust. So it might be called Green Acres Trust. Nobody knows the celebrity that actually is behind the trust. But once you sue the trust, you can find out who the parties are involved in that trust. How do you respond to a false cease and desist letter? This was a comment on a cease and desist video that I put out explaining how cease and desist letters work. And we'll put a link in the description below for that later. But the comment was saying essentially, if somebody sends you a cease and desist letter and either the action they complain about is not illegal or you didn't do it, how do you handle that? The general best practice is to respond and explain exactly that. So you explain, I either didn't do the activity that you're saying I did, or that activity isn't illegal. Now, you could just not respond and see if they actually do something about it. Typically, the next step in escalating from a cease and desist letter is a lawsuit. So you might get sued. Sometimes you realize, you know what, they're not actually going to sue. It's just not going to make sense. Like, say, for example, your dog made a mess on the neighbor's lawn and they had to clean it up. And they send you a cease and desist letter. You might just say, you know what, they're not going to sue over this particular incident. As long as it doesn't keep happening, we're likely to be fine. I'm not going to respond to the cease and desist letter. I'm not going to spend the money on legal fees for that, because the likelihood of a neighbor spending money on a lawsuit about a dog mess in the yard is not likely. But you might, or in many cases, I recommend clients respond to the cease and desist letter so that it doesn't force the other side to escalate. So let's say, for example, a business owner sends a cease and desist letter to an ex-employee who's violating a non-compete agreement. So the employee signed an agreement that says, I won't compete, and then the employee left and competes. If the business sends a cease and desist letter and the employee just ignores it, there's a good chance that business will commence a lawsuit there. So it's that sort of case where it makes sense for the employee to hire an attorney and either respond and say, I'm not violating the law, or say, hey, how can we work this out? And I've worked in both of those scenarios before, and often you can work something out. It might take paying some money, but I had one situation where the employee paid $50,000 to get out of the non compete agreement. And that was a better scenario for both parties because the business didn't want to have to spend over $100,000 in a lawsuit. And the employee didn't want to spend a lot of money in legal fees either. So they were able to work out an agreement where the business got some money and the employee was able to compete. Is it better to say yes or no to every opportunity? Perhaps you've seen this where YouTubers will do a little experiment where they will say yes to every opportunity that comes to them that day or that month. Or you might have heard books that have come out that have said, basically, if you want a full life, stop saying no or I can't do that. Say yes. Say yes to every opportunity and challenge that comes along. So that's one argument. The other argument is you should use discretion and prioritize opportunities and only select the ones that are best for your strategic goals. Um, which approach is better is essentially what this question was asking. When you're young, often it is fear that's holding you back from opportunities. And so, to the extent saying yes to opportunities helps overcome fear and challenges you to do new things like public speaking. So, let's say you get an opportunity to speak in public. Do you take it or not? Well, there's a great example of overcoming that fear and saying yes, great opportunity. But dating every person who asks you out on a date probably lacks some discretion. Taking every business opportunity that comes your way uh, with every person, uh, both the great opportunities and the wasteful opportunities, that just makes no sense. So I do think there's some value in at a young age not saying no to opportunities just because you're afraid of them and being more receptive to looking for opportunities and new experiences. But it still seems to me that discretion should guide you and you should prioritize opportunities. And that becomes especially important as we get older because you get so many opportunities. I read a newsletter this morning from John Jonas, the CEO of onlinejobs.ph, and he was talking about how important it is to say no to countless categories, feature requests, custom requests, new opportunity requests, strategic partner requests, new ideas, the latest marketing trends. Why? Because we have limited time and energy, and we need to focus that on the opportunities that really matter. And if we fill up our schedule like I'm guilty of, we don't have that margin to sit back and say, what's actually most important here? And how do I prepare to do each thing well rather than diving into the next thing and going through the rat race of life, being busy, but not strategically focusing on that which is meaningful and moves the needle or truly makes a difference in life. So, in this great debate over whether to say yes to everything and just be more receptive and say yes, I think there's truth there as far as not being limited by fear. But I think most people have way more opportunities than they should say yes to. And our greatest opportunity is starting to say no to a lot more, which then allows us to say yes to that which really matters. An author once said, if it's not a capital yes, it's a no. In other words, there are a lot of great opportunities that will come along, and maybe uh, they have some value, but it isn't a significant amount of value. The author recommended that you say no to everything unless it's a capital yes. There is definite value there. That's how I see a lot of networking events. You go to a networking event, you meet 15 people, you do some small talk. Some of the people are interesting, some not. You walk away. Was there value to that? Yeah, there absolutely was value. But was it the most valuable thing you could have done with the time you spent preparing for and attending that event? Uh, I often found that it wasn't the best use of time. All right, next question here. Should you have an LLC with a broad name and narrow DBAs for each niche? So the idea here is to have a single LLC with a more broad or generic name, and then use a DBA or a doing business as for each niche. It's an interesting strategy. And just as a little background, a DBA is essentially a nickname for a business. It's not a separate entity. So if you have an LLC, it might have subsidiary LLCs or child LLCs. Those are separate entities. We're not talking about that. We're talking about a DBA. A DBA is simply a nickname or an alias for an LLC. It's an alternative name. It's like if a person named Robert gets called Bob. It's not a different person. It's just a nickname for the same person. So, and I hone in on that because that is a common misconception with DBAs. People tend to think it's another category of business type like an LLC, S corp, or C corporation. It's not. It's just a nickname. So, imagine you have an LLC and then you have a DBA for one line of business and a DBA for another and a DBA for another. The only reason you use DBAs is for marketing or public relations purposes. There's no legal benefit to using DBAs. So the only question here is, does it make sense to use DBAs from a marketing perspective? I think that depends on the circumstances. A lot of times businesses choose not to use a DBA because they want to build one company brand among their customers in their target market. And the general view is that you should have one brand for and a consistent use of that brand in a target market. So for example, if your target market is tennis players, you would not want to have two or three brands for that same group. You want to use one brand so that they get to know you and they find, oh, you have great tennis shoes. You also have great tennis rackets and great tennis clothing. So they get to know that single brand for that target market. It raises the question, though, what if you have two target markets? Should you have two separate brands? From a legal perspective, it simply doesn't matter. It is all a question of marketing and branding, and that is probably beyond the scope of this show. Although I have a bachelor's degree in marketing, I focus this content on what is legal and what's not. And just keep in mind, DBAs have no legal effect. They are simply nicknames for a company. They're used for marketing purposes. Do you have to honor a non-compete agreement if the other party breached the contract first? This became a hot issue recently because Tucker Carlson left Fox News, and apparently he had a non-compete agreement with them. But then he opened his own show on Twitter, and Fox News claimed that Tucker Carlson breached the non-compete agreement that Tucker had signed. Tucker Carlson came back and said, "You breached that agreement first, so I don't have to honor it." So it raises the question, if another party breaches a contract first, are you relieved from performing under the contract? The general rule of law is that if the first breach by the other party goes to the heart of the contract, then you are relieved from the further performing under the contract. So I'll say that in a different way. If the party that breached first materially breached, so their breach fundamentally went to the purpose of the contract, then you are relieved from further performing your obligations under the contract. So Tucker Carlson's argument is true that if Fox News did materially breach the contract, then Tucker is relieved of further performing. But we know what Fox is going to say. It didn't materially breach the contract. It might have breached the contract, but that breach did not go to the heart of the contract. In other words, it was not a material breach. It was an immaterial breach or not material breach. Let me give you an example. Let's say that Fox News, and I'm making this all up now just to have a simple hypothetical. Let's say Fox News said, as once Tucker is terminated, he can't compete for 2 years. And during that 2-year period, he will be paid $30,000 per month as compensation for that non-compete period. And let's say that Fox News did not make those monthly payments. Well, that seems to go to the heart of that part of the agreement. I think Tucker Carlson would have a good argument that if Fox is not making its monthly payments, then Tucker is relieved from further performing under the non-compete term. But let's say Fox made the payment, but it continually made them 2 days late. Is that a material breach? Most courts would say no, that's not a material breach. Tucker still got the money. It was just held up for 2 days. And if that didn't make a big difference in Tucker's life, having to wait 2 days, it's not a material breach. Let's say that the payment came from Fox News to Tucker Carlson, but a wire transfer fee of $30 was removed from the $30,000 payment. So Tucker Carlson's payment that he received each month was $30 short. Is that a material breach? In other words, does that go to the heart of the agreement? No, $30 isn't that big a deal in the context of a $30,000 monthly payment. That would not be a material breach. So that means Tucker would not be released from performing under the non-compete agreement. He would need to abide by the non-compete agreement. So as you can see, the question of whether you have to perform under a contract depends on whether the other party materially breached the contract. And honestly, that's not easy. It's not an easy analysis. It's not even easy for attorneys who work in this space to figure out. For example, if I said, I'll pay you $1,000 to paint my house, and you paint everything but the gutter, or let's say you paint everything but one of the doors. You got 99% complete. Is that a breach? Is that a material breach? I think most courts would say no. But let's say I asked you to ship a load of materials from Japan to the United States. and you got 99% of the way there, and then the ship sank. And so I didn't get my materials. But you did 99% of the work. Is that a material breach? I think a court would say, yeah, it is, because I didn't get the products. Sure, you may have done a lot of the work, but at the heart of the agreement, I wanted the materials in the United States and they didn't get here. So as you can see, it's not enough just that you do 99% of the work. There are a lot of factors a court will consider in determining whether a breach went to the heart of the agreement. Or when I say heart of the agreement, I mean the fundamental purpose for which the agreement was formed. Taking a look here at other questions that we have. How can you force out a business partner? So here's a little bit of context for the question. My business partner was great in the beginning, but now he's awful. I can't continue to do business with him. How do I force him out? This is tricky. Under the law, you can't take away somebody else's ownership of a business just because they can't do the job. So here's what the law is in most states. When you own a small business, nobody can take away your right to ownership in the company, with a few exceptions for fraud and stuff like that. But let's set that aside. So you own the company. But a lot of times, your ownership in the company doesn't produce any benefit to you other than your job and the wages you receive from that job. So, say, for example, you have two chiropractors and they are both owners, 50-50 owners of an LLC. And if one of them is fired, they essentially lose the whole benefit they have in that chiropractic office. They would also stop working there, and so it would probably generate less proceeds. But let's just say that the main benefit of this small business is the wages you get from the job that you're able to work. So if somebody is fired, if a business owner is fired, they may lose all of the benefit of owning that company. Is that fair? The law has said no, it's not. It's one thing for a person to be fired from a large publicly held company like Apple, uh, Google, Honeywell, Burger King, etc. But it's quite another thing if a couple business owners own a small business, they work in the business, and most of the benefit or the money they get is from their job. If you let another business owner fire them, you've essentially robbed that person of the entire benefit of owning a part of that company. So in small businesses, the law generally says you can't fire them because that would take away their ownership benefit. Now, if you had a contract that said they could be fired, that's a different story. But if there's no contract, the law says business owners have an expectation of employment in their company if that was given to them as part of their ownership of the company. So what are you supposed to do about this if you can't get along? Well, here's one scenario. There was a business owner, and as he aged, he struggled with certain functions like using the computer. And that was exacerbated by the fact that the company continued to update its computer technology, and this senior owner had a difficult time learning the new technology and using it. And when this went to court, the judge basically said, you don't have a right to just fire this guy because he can't do the job. You need to make reasonable accommodations for him. So, for example, get him an assistant who can help him with the software, get him some training. And if he can't do the job, find another job in the business that he can do. So, I think the takeaway here is that when you go into business with somebody, you are often stuck with them. And so it's really important to be selective in the business partners you choose. And then also to have in writing an agreement about how you will separate later and how you will handle different scenarios. Those scenarios might be you don't get along, you don't agree on the vision of the company, one of you aren't doing a good job, at least in the opinion of the other owner, a divorce, a bankruptcy, incapacity, an injury that takes somebody off the job. All of those pieces are what's usually covered in an operating agreement and a buy sell agreement. So, when setting up an LLC or a corporation, you usually have agreements among the owners about how to handle all of this stuff. The operating agreement in an LLC is the same as a bylaws in a corporation. It basically sets all the internal rules. And then one optional add on to that is called a buy sell agreement. And that's where one owner can buy out the other in scenarios like death, bankruptcy, divorce, or somebody not doing the job well, or other disagreements that might come up. Unfortunately, business owners often don't do that in the beginning because they don't want to spend the money on legal fees. They're trying to prove the business idea first. They're busy growing the business. And so often I see if business owners don't do it in the beginning, it gets put off until there's tension between the business owners. And that can be a very expensive time to and difficult time to try to resolve differences that have arisen. It's especially challenging too because often when there are issues, trust starts to erode, and resentment builds. And so now you have those emotional aspects causing conflict and distraction in trying to put together a kind of like a prenup or a framework for separating as business owners. So if you're running a business now and you don't have, or you have business partners and you don't have an operating agreement and a buy sell agreement, now is a great time to get that in place while you are getting along with the other business owners. So, can you force a business partner out if you're not getting along? No, uh, except if your contract says so, you can follow the terms of the contract, or if you go to court. A court can dissolve a business and force the partners out, or force one to be bought out for a fair market value. When negotiating a non compete agreement, what are alternatives besides yes or no? In other words, let's say there is an employer who wants a non compete agreement signed by an employee, and the employee says, I don't want to sign that. Or maybe it's a contractor. Or maybe the employee or contractor already signed it and is now trying to figure out, can I get out of this? A lot of times people think, well, you can either sign it or not. But what are alternatives to that? One common proposal that I've seen is where there will be a non compete period. Let's say it's 2 years, but the employee will be compensated for the business at a certain rate each month that that business wants to keep that non compete period. So, for example, the agreement might say if the business fires the employee or the employee quits, for every month the business wants to enforce the non compete agreement up to 2 years, the business will pay 80% of the employee's prior wage to the employee. What I like about this approach is the business has the option to protect its legitimate interests and keep the employee from competing, but it also is paying the employee something significant for that. And to the extent the business doesn't actually need the non-compete to be enforced, it can stop making payments and the employee can then go out and compete and get a job in that industry or in that space. So that's one example. Another example I've seen is where instead of agreeing to a non-compete agreement that says the employee can't compete in an area, the parties instead agree to a non-solicitation agreement. Here's what that is. A non-solicitation agreement says the employee will not solicit customers, prospects, or employees of the employer. So the employee can leave and go compete, but won't interfere with the relationships that drive revenue for the employer. So, for example, the employee might go out and start a competitive business, but will not solicit any of the prospects that the employee had a relationship with, or the customers, or the prior employees of the employer for a period of time, maybe 2 years, for example. In most states, if not all, non solicitation agreements are enforceable. In many states, non competes are banned or significantly limited. So, whether a non compete is even enforceable in your state is an issue of state law. Taking a look at the next question here. If a trust and power of attorney conflict, which one prevails? It's very difficult for me to even think about a scenario where they could conflict. And here's why. A trust is a document that sets up authority for a third party to manage money or assets. So that third party is called a trustee. We'll call him the manager. If you have a trust and you designate a manager of the trust, let's say that's your friend Joe. And then you have a power of attorney. And the power of attorney would either say that the person you're designating can handle all of your affairs, or it might be a power of attorney for the trustee and the trust. Usually that's not the case, though. It's a power of attorney for you and your affairs. So if you appoint a power of attorney, that attorney, it's called an attorney in fact, can come and act on your behalf and do anything you could do. But you're not the manager of the trust. So the attorney does not have the authority to come and do anything in the trust. Now, if you are the manager of the trust, then yes, that person could usually act under the power of attorney and handle things within the trust. So it would be extremely unusual for a trust document, a trust agreement, which has all the rules regarding the trust and what the trustee can do. Be extremely unusual for that to conflict with a power of attorney. But let's just say hypothetically, if they did conflict, the, there's another general rule of contract interpretation, which says the specific provision prevails over the general provision. This is a guiding principle in the common law, which has been recognized in most, if not all, states. So, in other words, if all things are equal, the provision that is more specific prevails over the one that is more general. Let me give you an example. Um, let's say that the trust agreement says Um, Under no circumstances should any property be sold uh, before the year 2030. And then let's say that there is a power of attorney for the sale of specific property under specific circumstances. And let's say that is referencing the trust and authority under the trust, and all other things being equal, that power of attorney would apply. The question then becomes, which provision prevails? The one that said nothing should be sold before 2030, or the provision that says in a specific circumstance, the attorney in fact can sell this specific property? Because the law basically says there was a lot of intent and thought put into that specific provision. So that should prevail over the general provision that just said there shouldn't be any sale of property. This applies to provisions in the same contract. So this concept does, and it also applies to provisions in separate contracts and separate doctrines. So all other things being equal, the specific provision prevails over the general provision. But again, I've never seen a trust and a power of attorney conflict, and it'd be a very rare circumstance. There are also many other rules for contract interpretation that may be applicable depending on the circumstances. When does a non-compete agreement expire? It expires whenever it says it does. So it might say it expires after 2 years. So let's start with that. But if it says it expires after 40 years, that may not be enforceable under the law. And so a court may determine that it expired before that. There are courts that will apply what's called the blue pencil doctrine. And what that basically says is, imagine a judge with a blue pencil takes a look at the contract, and the non-compete contract says the employee cannot compete for 40 years. And if the judge knows that that is too long of period, only 2 years is enforceable in that state, the judge would strike out 40 years and write with a blue pencil 2 years instead. That is an example of the blue pencil doctrine. It basically means the judge can modify the agreement to an enforceable limit or an enforceable period of time. So if we first, in the analysis, we first look to what does the agreement say? And if that's too long, we look to, does the court apply the blue pencil doctrine in your state? And if the answer is yes, then it's probably going to be the maximum allowed under law in your state. If the court does not apply the blue pencil doctrine, then that entire provision may be stricken from the contract by a court because it may be a violation of public policy and thus unenforceable and void. In that case, it wouldn't be limited to 2 years, it would just be stricken. So we look to 3 things. What does the contract say? What's enforceable in your jurisdiction? And then does your jurisdiction have the blue pencil doctrine, or does it just completely void provisions that are too broad or not enforceable? Another scenario where a non-compete agreement might expire is where the company is terminated. So if you have an agreement between 2 parties and one of the parties is a company that dies, well, with that party no longer there to enforce the agreement effectively dies as well. That can be the case with people who pass away, but sometimes their estates keep the right to enforce contracts that existed prior to the person's passing. So with companies terminating, usually the contracts terminate as well. With people who terminate or pass away, It depends on the circumstances and state law. Does the Minnesota non-compete ban affect contracts signed before January 1st, 2023? No, it doesn't. There was a huge law passed in Minnesota that banned non-compete agreements in all sorts of circumstances, both for independent contractors and employees. But this law specifically said it only applies to contracts signed on July 1st, 2023 and later. Any prior signed non-compete agreement remains enforceable under the old law. Now, the extent that this new ban will stay as is open to a lot of questions. This ban was so broad and so extreme that I believe it's likely the legislature will revise it and tighten up some of the problems that are created by this ban. I'll give you an example. Let's say that a news outlet, let's say KARE 11 News, wants to hire a new newscaster and says, you know what, we want you to agree that if we build your personal brand and we talk about your name and we feature you, you're not going to go over to Fox 9 News. Well, currently under the non-compete ban, if the KARE 11 News employee signed a non-compete, that provision would be void and unenforceable. And after KARE 11 builds a lot of name recognition and brand awareness with that newscaster, maybe even makes that newscaster an anchor on the evening news, that newscaster could now negotiate with Fox 9 to get a job that pays a lot more than KARE 11 would pay. And the non-compete agreement that the newscaster signed is not enforceable under Minnesota law. So what is KARE 11 to do? Well, what it ends up doing is being very careful about not putting a whole lot of brand building in a particular personality, because that personality could transition to a competitor at any time. It forces KARE 11 to focus more on building its brand and less on the individuals involved. There are other scenarios where a person might want to, or a company might want to hire a person to be a spokesperson. And they want to make sure that spokesperson won't go to a competitor. Well, right now, that is essentially a prohibited act because you can't prevent a person from competing. That non-compete agreement is simply not enforceable. So I expect that's one of many examples of the type of tweaks we'll see in the law, so that when a person is hired as a spokesperson for a company, the the non-compete will be enforceable under certain reasonable limitations. All right, let's cover one more question here. How can you find a world-class mentor? So a lot of people, as they're growing up, they would love to have a mentor. You may have heard the saying that you are the average of the 5 people you spend the most time with. So it goes without saying, you should try to find some great people to be around. And one in particular is a mentor. You've probably seen the books and the YouTube creators and influencers who talk about how important it is to get a great mentor, maybe great mentors that they had. But let's face it, a lot of us, we don't know those people. We may not be in the cities where they live. We may not be able to afford the rates that they would charge for mentorship. And some of the people that would be great mentors for us simply are not taking time to mentor. So, what do you do about this? How do you find a great mentor? Well, here are three considerations. First, one option is to find somebody that fulfills the requirements that you're looking for and try to provide value to them. Maybe that's working at a nonprofit with them, maybe it's helping them with something. But let's face it, that can be very difficult. Another idea that I heard recently was that artificial intelligence can essentially absorb all of the data related to a particular person, all their writings, their speeches, their stories about them. And once that's absorbed into artificial intelligence, you can have a conversation with them and say, like, hey, Steve Jobs, what would you do in this situation? I don't have the confidence in artificial intelligence at this point to be basing life decisions on something like that. So I'll tell you what I've done. Um, I have wanted to learn from some of the most extraordinary people. And fortunately, I've had opportunity to work alongside some great people, nobody you've known. But if you're looking for a world-class mentor, one of the things that struck me is we have an opportunity these days like like never existed in prior decades. We are able to listen to audiobooks and hear the best thinking from world-class thinkers, people who have done extraordinary work and then put the concepts together in books. I'll give you an example. Ray Dalio, who runs a multi-billion dollar hedge fund, who's had extraordinary success in many categories in life. Does he have time to mentor me? No. In fact, it'd be I'd be surprised if he had time to mentor anybody. But what he has done is put together some of his best thinking to pass along to future generations in a book. And in fact, I just listened to the audiobooks. Or let's take somebody like Elon Musk. Many people idolize him and say, hey, he would be an incredible mentor. Well, obviously, he doesn't have time to run this. He's running Tesla, SpaceX, the Boring Company. He's managing the new CEO of Twitter. He has his hands in many other investments. Does he have time to mentor? No. But what he does have, or what we can do, is capture interviews of him, presentations by him, stories about him. So as we think about, if we are people who don't have access to world-class mentors, we do, though, happen to live in a unique time where you can get some of the best thinking, best conversations, and best speeches right now available on the internet, either for free or through audiobooks. So let's imagine that you are growing up in a family where you don't have many successful people around you. You don't have many wise people or knowledgeable people or educated people around you. In fact, you look at the lives of the people around you and you say, I don't want that. How can you, as an average person, go get a mentor that helps you out of this? Well, what I do is I try to saturate myself and surround myself with the voices of incredible mentors and their best thinking through YouTube videos, podcasts, and audiobooks. So that's a little different approach than actually getting a mentor, but it's a realistic approach that everybody can do. When I was young, I used to think, oh, wouldn't it be amazing if I could sit next to, and then I would name some leader, like be a fly on the wall and hear conversations, or, say two leaders have conversations between each other. Wouldn't it be incredible if I could listen to that conversation? Well, these days we have that. We have experts who interview other experts, whether it's Malcolm Gladwell interviewing some famous author or some famous CEO or some famous athlete. Being able to listen to those conversations is a virtual way of surrounding ourselves with wise people. So, how can you find a world class mentor? There are tips on the internet. Maybe you can find them, but a really great second best option is finding what they've written and the discussions they've had and saturating yourself with that, whether you listen to them on walks, while exercising, while driving, whatever you do, finding that wisdom and surrounding yourself with it, that is a great way to offset the fact that a lot of us simply can't find these incredible mentors who will allocate time out of their schedule to help us in our personal lives. I've also observed that although I may not have one mentor in all categories, there are people in my life who I do admire in specific categories. Like, for example, I might admire a person in parenting. I may not think this particular person is great in every category, but in the area of parenting, I can ask that particular person questions. Or a person is good at socializing and conversation. And I could ask that person, when you approach a room where you don't know everybody, what's your mindset? What preparation do you do to have thoughtful and productive conversations and engaging conversations with people? So in other words, we may not have one mentor who has all sorts of wisdom in every category, but to the extent we can find little niche experts in our own lives, that may be possible. Um, and it might be simple things like, how do you enjoy life? How do you stay physically healthy? What have you found works well in raising daughters or in raising sons? Or what has worked well in your relationship and investing in your marriage? All those sorts of questions. You may know people who do that category well, and they at least can provide a mentorship in those particular categories. All right. Well, thank you for joining me here today on this live stream. If you would like more information on me, you can find it at aaronhall.com. If you would like to follow us on other platforms, just search for Aaron Hall Attorney on the various other social media platforms. And if you have other questions, I'd be happy to see about answering them in future YouTube live videos. Feel free to add them in the comments below, or you can submit them to us using the form listed in the description below. It was great talking with you today. I hope this was helpful, and let's stay in touch. You can sign up at aaronhall.com/free if you would like to receive those exclusive training videos for people who are trying to avoid common problems in small businesses. Have a great day.